So thank you for joining me. My name is Maureen Macmanus, and I am the founder and creator of BarMD. We are a full service bar prep company, so we have everything you need. I'll talk about some of that stuff that we provide in the beginning here, and then we're going to dig into these essays. So, and I know there's so many familiar names. I'm happy to see y'all. And if you guys have questions, definitely feel free to put them in like the Q&A. If you have a specific question about, a particular essay or something, I can talk about that. Oh, Melina, it is separate. It is separate. It's just that you, like, in terms of like, how do you do it, manage timing, it just incorporates in. All right, so let's get started. So today's objectives, we're going to talk about the issues in the February 2024 bar essays. We're going to go through those 5 essays. They were tough. So if any of you felt like they were tough, I absolutely agree. I thought that they were pretty tough. There was some tricky stuff in it. A lot of stuff that's a bit of a gimme, but definitely some tricky stuff too. So I hope that you will feel better after you go through this. Also, the one big thing I will say, if you see something and you're like, oh my God, I didn't talk about that, or like you think that you didn't address an issue, you don't know that. Like one of the biggest things that my takeaway from law school is when I would take an exam, then, it's 4 weeks later or whatever that you get your exams back. I would be like, oh my gosh, I didn't talk about that issue at all. I completely missed that. I must have failed. And then I would get my exam back and I would actually do okay. And it turned out that I did talk about the issue that I thought that I didn't talk about. So that happens all the time. So don't assume that because you don't remember doing something that you don't remember it. There's so much going on that day. There's so much in the essays. We block out so much. So you can't totally rely on your memory. So just throwing that out there. And we're also going to talk about the PT. I will separately do a PT workshop where I do a deep dive into this performance test. I always do that. This is really much more of a big overview of what the issues were, what, kind of how to organize. So that being said, let's get into it. So here also, I'll put in the chat for everybody a link to the essays. I actually think I can drop the PDFs. Yeah, I will do the PT deep dive before the July 2024. Yeah, it'll be in the next few weeks, probably early May. We also have, just FYI, we have a ton of free workshops that I've already scheduled coming up. So if you want to sign up for those, I'll give you the link. We have tons of free resources on my website, free courses, like free previews. We're actually going to update these soon too. I'm really excited. I've been busy working on stuff, but here's a link to our free study resources. We haven't put all of the various free workshops coming up. They're not all here, but this is where you would find it, and like samples of our books. Speaking of, let me talk about those for a second. So some free resources. So here, totally free. We have a BarMD Facebook group, just where like if I'm going to do a workshop, I announce it there. If you guys have questions, substantive law questions, I can post it there. You can post it there and I will answer it. I go through it pretty regularly. We have also a BarMD strategies, like free workshop course. That's where a recording of this particular workshop will be posted. That's in BarMD strategies, which I'm going to put a link for y'all to sign up in the chat. So bar exam strategies is right there. So that is a free resource that is really helpful. I also have a podcast, which I didn't update during the last bar cycle, but I do have a bunch of stuff planned for this upcoming bar cycle to do. A lot of people I do these, 10, 15-minute overviews of a particular area of the law. So, when you're like in a commute or like on a train or whatever, or out for a walk and you want to like get some studying in, but doing something else, I have my podcast, which I'm going to put the link here. And also, if you guys have certain things you want covered on the podcast, let me know, like in the Facebook group, let me know and I'll address it. Cause sometimes I'm like, what am I going to talk about this time? I feel like I talk about so much. Let me get y'all a link to the Facebook group as well. It's a closed group, so you just have to ask for permission and I will grant you access to it. So there's the link to join the Facebook group as well. So click on that and I will approve your requests to join. And then the one-on-one strategy session, I'm doing these for the most part. You can have a one-on-one session with me. It's limited to one per study cycle, like one of these free sessions, just because I literally do hundreds of these. So, try to keep it to that, but let me get the link to that posted as well. So if you want to have a one-on-one session and talk, that's Totally fine. And then also like we do this again also when bar results come out. So if you get your results and like hopefully everybody gets good results. And if you do, please let me know because I'm so excited and I like to celebrate with everybody. And then if you don't get good news, like all it is data and we can look at it and figure out a plan. So, but we won't really think about that. Just as a couple of little plugs here, we do this this course called Early Intervention. This is like an early bar prep. So it's really designed to be encouraging and also to like review skills, and review some black letter law and like big issues, big topics. So it's 3 weeks, is over the next 3 weeks. And it's 6 workshops. I'm teaching it along with Kate Bola. So she also teaches my essay course as well. It's a mini review of all of the 7 MBE subjects. There's essay approach tips. We'll talk about different essays in all of these subjects. It includes 210 real MBE questions and answer explanations. And it's really designed so that you go into the exam just so well prepared and knowing like, all right, when like real studying like hits in May, it's an intense study period, May, June, July. I want you to know like all of the skills you have to know, like how do you appropriately address an essay? How do you organize? How do you write analysis? How do you write counter arguments, etc. So all of those things, and it's designed for California and the UBE, if there's any UBE people here. And all of it's recorded, they're posted within 24 hours. So it's a really and it's $99. It's a pretty good deal in my opinion. So yeah, it's really designed to just amp it up. And if you took the February bar and you're waiting for results, but you're like, all right, well, let me just prepare anyways, you can take this class. I just put the link in the chat. You can take this class. And if you find out that you pass, we'll refund you. Like totally, like no questions asked. We also have early intervention. It starts tomorrow. So you'd want to ideally sign up tomorrow, but you can sign up late and then also, watch it back too. We also have our books that are out, and the UBE versions of these are going to be out by May 1st. So I'm super excited for those to be done. But I have my essay book. It's templates for how to address anything on the bar. Basically, there's a few things I intentionally omit because if something's only been tested once, I don't want you spending time committing that to memory. So there's comprehensive templates. It's basically fill in the blank analysis. So that's the big thing that separates this book from other stuff and I'll show everybody a sample of it. And we do have a free sample for you to download on my website, a free sample of like a portion of it, not the whole thing. So I will show you all that. Thanks, Gina. That's awesome. I will definitely send it to you. So I like to be very thorough and comprehensive in like what I am providing. So this is a sample. Let's see. This is a sample of my essay book, or this is the full book, but just showing it to you guys here. So for a particular topic, especially big topics, we have an overview, like how it gets tested, how you might see it show up, also distinctions between federal and California. So I will go and give you, talk to you about, okay, if you see this issue, this is what to do. And then here's the template. So it has the rules in here, and you'll see there's footnotes in it where I'm explaining stuff even more in depth. But it's different from having an outline. An outline, you'll have all of the information within the outline. But I want to show you, what do you need to include in your essay? What do you actually need to write? What do you need to memorize? And what can you just be like, okay, I understand these other rules, but you don't need to type it, right? Because the bar, it's such a test of time management, and also law knowledge. But for so many people, they get so rule heavy and they're so focused on memorizing rules and being able to regurgitate all the rules that then they run out of time on actually writing the analysis, when the points on the bar and on the essay are in the writing, they're in the analysis. So this book is really designed to help you very strategically with the essays. And then it's fill in the blank analysis. So here you pick, here the claim either does or does not involve the same parties or privies in the same order because what facts? And so you just fill in the relevant facts from the fact pattern. So I actually write the analysis for you and you fill in the blanks. There's also stuff, so you have the footnotes and the ME ebook, yeah, all of these are available digitally, and there are hard copies. For California, the hard copies are already available. With the ME ebook, the hard copies will be available. They'll ship in probably a couple weeks after they launch, but you'll have digital access right away. And then we also include some grade out rules. So a grade out rule is something you might include if you have time or if it's triggered by the facts. So I really want to show you strategically how to answer an essay. So that's really what I do here in this book. So that's a sample of this book. Just wanted to show you all that. So that's the essay book. The UBE one is forthcoming. That will be out, like I said, very shortly here. And then we also have our PT book, which people love, and our MBE book. The essay book is $149. It's $149. And then if you want it for the digital only, if you want the hard copy also, it's $189, and that's shipping and everything. Then also the PT book, let me show y'all. So the difference with the PT book, and it's the digital is accessible for the exam period, but if you need it again, you can just let us know and we'll turn it back on for you. So with the PT book, also again, digital plus the hard copy. So it's the first 5 chapters or first 5 chapters really explain how to write a PT. So a lot of you might have seen my free workshops that I do where I walk you through it. This is me taking all those thoughts and putting it down into paper. There's a study plan. This book is actually in color, which is why these books are a little more expensive, is because of the color printing, because I like to color code and give you that visual example. In particular, like there are examples like this with formulas. I like to give a lot of examples. So that's in here. So I walk you through how to do everything, how to write a PT, formulas for writing the analysis. And then what I think is unique, yes, it includes all of the subjects, including the PT book is separate. The PT book and the essay book are separate, but it does include all the subjects. And it's short because it's a smaller font, which to make it not so heavy to lug around. And then for every single PT that's in here, which I think there's like 10 or so for California, I give you an overview. That's the process. Let's see. So like, here's the first one that's in the book that's complete. So I will talk about the PT a little bit. Yeah, so here's the PT. I give you my marked up file and library. So you can see, okay, did you notice the same things that I noticed? Did you extract the same rules? Did you notice the same key facts that I noticed? Did you annotate it and pick up on things like I did? So I give you the sample. Here's my marked up library. And this is why it's printed in color too, is because it's color coded. I want you to see. I highlight the rules, I think, in yellow. It's all the same colors throughout the whole book. So yeah, rules, and then the analysis. Here's the issue. There's the analysis. I think it's policy. There's another case in there. Anyhow, I'm scrolling through it quickly just to sort of show you marked up file, marked up library. And then I give you a breakdown of what happened and like different ways you could organize it. So because one thing that happens all the time, like with a PT, and this is also like something, like if you did something a different way than I did, it's oftentimes okay as long as what you did is logical and makes sense. And this is true for the essays too. You just have to do it in a way that is logical. So I like to explain here in the beginning, all right, well, with this, you could have done it this way or that way, or, different things so that, because reasonable minds can differ. So then I show you step by step how my PT got put together. So you can see that here. So after step 2, after step 4, what it looks like. After step 5, what it looks like. And then there's the final draft. So we do this for all of the PTs with the marked up file and library, it's color, and then the final draft. And just one thing I want to point out, there are some typos in the answers. That's intentional because I want you to see that typos are okay. Like it doesn't have to be perfect. I like mine to reflect what is actually okay on the bar. So there's that. So this book is $99. And then if you want the printed copy, it's $139. So, and this is available on the website. Then we do, how many of you guys have a harder, for people here, I'm curious, what's tougher for you? Essays, PT, or MBE? What is it that gives you trouble? Should I do a little poll? MBE, PT, MBE, essays, PT. It's a huge split. PT, MBE, all of it. Essays, MBE. Hi, Aida. Essays, yeah. Yeah, so, but like all of these things, I just like to say, like all of these things are very much figure outable. So it's really a matter of like, all right, like it's a matter of like understanding how each thing is put together so you know how to pull it apart. That's really like where it's at. So the other thing we have that I'm very, very excited about is my MBE book, because it was just a beast to put together. I swear it nearly broke me, but we have this book, which is, this is unique. Thanks, Jack. It's unique, I think, compared to everything else, because I'm really big on structure and process and making sure that like the bar exam has a massive amount of material that you have to know. There is so much law. Do you guys all agree? Like it's almost overwhelming how much black letter law you have to just know and have memorized, right? So that's, I think, challenge number 1 is the quantity of material. So I always like to break it down into tiny little pieces. It's bananas, right? Thanks, Gina. I was surprised I didn't get a ton of like yeses. It's insane how much we have to know, but right, it is, right? I think everybody agrees. So I like to make it like in the essay book, I break everything down into like tiny little pieces. It's like, all right, here's all of the things broken apart that you need to know, and it's very digestible. And I show you how to analyze it, what it looks like, the way that, you know, the different ways you might address something, and how much of that do you really have to know and be able to like type out, and how much is it that you have to just like understand, but not be able to regurgitate. So, or where you don't have to like, you know, strain to memorize a certain level of information. So with the MBE, there's a quick intro. And then what I do is I go through every single subject and I break it down into little pieces. So for civil procedure, there's different sections. So there's jurisdiction and venue, law applied by federal courts, pretrial procedures. I break this down according to how the MBE is broken down. So I break it in the same thing, and I give you all the black letter law. And then there's questions, MBE questions that are real, that test you on those topics. So for example, and there's tips and everything woven throughout. So I wanted to sort of take what is, I think, the best of the materials that are out there. So you have strategies and tactics, there's MBE decoded. What else is there? I mean, it's really like those two things, plus having like an MBE program. And like all of those things need to be sort of in one. And I wanted to make a resource that did that. So, and gives you structure, because that's my biggest complaint with Adaptive Bar New World, is that there's no structure, and people need a course. You need to know how many MBEs should you be doing every day. So what I did is in this book, I give you a schedule that's 75 days, and it incorporates either Adaptive Bar or U World. And I tell you how many questions to do, which subjects every day. And if you follow the schedule, you will get to the bar. You will get to the bar knowing, like having done a sufficient number of questions. What is like, you know, most people need, which is about 2,000 questions. You will do that if you follow this schedule. So that's one thing that I'm really big on. So I do incorporate that here. It's all in here. So I want to give you guys structure, because we all need that. At least I needed that. I know most people that I work with need that. And then I want to make it, you know, bite-sized, make it so that you can actually do it. So I always start with civil procedure, give you a whole overview on civil procedure questions on MBEs, the issues that there are. There's a book that I recommend for civil procedure questions as well, talk about how to do things. So there's tips for Civ Pro, just generally. And then what I do is I give you all of the black letter law for a particular topic. So jurisdiction and venue. So all of the black letter law is here. And then you get through that. I can't actually put them up here, but because of licensing, then you will see there's a section here with new questions. There's 410 questions in the book. So with questions on jurisdiction and venue that are in here, I'll just scroll past it quickly. So there's like on jurisdiction and venue, there's 11 questions. And then we have the answer explanations directly following. I also think it's really important for you all to practice on paper, because that's how the exam is for now. California's doing kind of a crazy thing in February 25, but we don't have to worry about that. But that's what this book does, is it gives you the black letter law, then it gives you targeted questions and answer explanation. It's all broken down into bite-sized pieces, 11 questions here, 10 here, and it's just really designed to show you how things are tested in the exam. So anyhow, all right, let's dig into now what we are all here for, which is the essays from the bar. July 24 will be in the same current format. There's no changes. So let's read through the fact pattern first. The book, yes, the book has 410 MBE questions in it. Yeah, and I will drop the questions into the chat once again, the essays and the PT. So let's read through the questions first. The MBE book, if you want it with the hard copy, it's $199. And that's because a huge chunk of that goes to pay for the questions. So essay number 1 was community property. Not a terribly crazy community property question, a little bit ambiguous in some spots though. So first, call the question. What are Henry's and Wendy's respective rights and liabilities, if any, regarding? This is a classic community property setup. So it says here, Henry and Wendy married in California in 2012. Henry got a job as an auto mechanic. Wendy's aunt, who owned a house free and clear of any mortgage, gave it to Wendy. Wendy then added Henry on the title document to the house. So we'll talk about these issues in a bit. I'm just going to read through the fact pattern, and then I'm going to go through and talk about the issues. When Wendy and Henry lived in the house, Wendy then began singing with a local band. Some years later, Wendy and the band began traveling and performing across the state. The band was profitable, and Wendy sent money home to Henry and stayed with him periodically. This doesn't sound like it's going to be a successful marriage, and pretty much everything ends in divorce on the bar. So Henry decided to purchase an auto repair garage and applied for a loan from a bank for that purpose. Because Wendy was on the road with her band, Henry forged Wendy's signature on the loan documents without her knowledge, which breached fiduciary duty. The bank approved the loan using the house as collateral. Henry purchased the auto repair garage with the loan funds. Title to the auto repair garage was taken in Henry's and Wendy's names in joint tenancy. After a while, Wendy told Henry that the marriage was over. She stopped returning home and also stopped sending money to Henry. She began making independent investments with her earnings. Henry was unable to make the loan payments, and the bank demanded payment of the loan in full. Shortly thereafter, Wendy filed for dissolution of the marriage. So what are the rights and liabilities regarding the house, the bank loan, the auto repair garage, Wendy's investments? So you want to start by addressing what is the marital economic community. You don't have to do this, but I like to. So it would be 2012 until Wendy said the marriage was over. So that's what I would start with. So the house. The source of the house was bought with separate property. So the house was bought with separate property because it was an inheritance that went to Wendy. So that was Wendy alone. It wasn't to both of them. So she inherited it, or it was not an inheritance. It was a gift, rather. I should say it was a gift. Transmutation. So then I'm like, okay, well, she then added Henry to the title, on the title of the document to the house. So was that an effective transmutation? Almost with every community property issue, I'm looking to see, was there an effective transmutation? There usually isn't, because you need to have a writing, and there wasn't an effective writing here. But form of title, there's a here where they both live in the house and you're both on the title of the house, then we presume that it's a gift unless there's a contrary written intent, and there is no contrary written intent here. So the conclusion here is that it is community property. So that's split between H and W equally. The bank loan, source, community. And Smita, if you can just type your question in the Q&A, that would be great. So the bank loan, the source is community, because debt, any debt that's taken on is basically community debt unless somehow otherwise arranged. So the debt here would be community debt, but there was a breach of fiduciary duty because he forged W's signature. So yes, you would do Lucas anti-Lucas here. Yeah. And W may be but because there was a forged signature, W may be entitled to reimbursement. But the end of the day, this is still going to be community property. So the bank loan will be it's a community debt, but W may be entitled to reimbursement because of H forging her signature. Auto repair garage, he took out, so it was a debt, right? So it was his business. We were having a debate regarding, are they really wanting, usually when you see a business, there's usually going to be a Prairie Van Camp issue, and there isn't here, which we thought was sort of surprising, but we know that there's no issue. There's not an issue here with Prairie Van Camp, because there's no facts regarding Prairie Van Camp. So usually they give you some facts on the valuation, et cetera, and there isn't any of that, or telling you like how, that it increased in value or decreased in value or whatever it is, right? And they'll tell you how much labor went into the business. And, was it the labor that caused the increase, or was it just the value of the business itself? So they don't give you those facts here. So if anybody was worried about, the fact that they didn't do Prairie Van Camp, that's okay. So community debt plus community labor went into it because H is working there. So the source is its community. Title was taken in both of their names. So the conclusion here with the auto repair garage is that it's community property. And if you discuss just to throw it, you won't lose points. Like absolutely, you absolutely will not lose points, but you didn't have to do a big, Prairie Van Camp discussion here. All right, last thing, Wendy's investments. So this one, I thought there was a little bit of ambiguity. So the source is she's making these investments post-separation. They made that very clear. It says after a while, Wendy told Henry that the marriage was over, and then she starts making independent investments with her earnings, though. So it's because, it depends on when these earnings came from. If the earnings that she was making the investments with, if those earnings were from her prior earnings, because they said previously that like from the beginning, the band was profitable, which is like alarmingly shocking. So it's a little bit unclear. If the earnings were from pre-separation, they would be community property. But if they were post-separation, then it would be her separate property. And yeah, the fraudulent signature, I wouldn't discuss fraud. I would discuss it's a breach of a fiduciary duty because he fraudulently did it, but you wouldn't actually discuss a fraud claim. I wouldn't discuss Hug and Nelson because that's for stocks, and we don't know what these independent investments are, and they haven't talked about that. I think Hug and Nelson is stocks, right, from what I recall. So you didn't have to do that here. We also don't know about the value of it. So a question specifically about this one: the house was Wendy's separate property, but when she added Henry, it changed the house's character. Yes, a transmutation is something separate. Like you can. I thought about this too. Somebody saying, okay, well, isn't it a transmutation because she put his name on the title? And you can definitely make that argument. I think that that's valid and worth making. But with form of title here, when you put both names on it, that's just presumed a gift. So there's a rule for form of title. So that's just a bit more specific of a rule to include here regarding the house in particular. Somebody else asked on this, would I discuss exhaustion regarding W's investment? I wouldn't do like a tracing analysis. You could, but like there aren't facts really about it. But yeah, I guess you would trace it to say, okay, well, is it, from her pre-separation or post-separation? Jocelyn, yep, that's what I addressed. All right. And then someone also said, just saying the marriage is over doesn't mean it's over, but she says it's over, plus she moved out. So like that is sufficient. That is sufficient for separation. They haven't gotten divorced. Well, she filed for dissolution after. They filed for dissolution after. But here, Wendy said the marriage was over and then she stopped returning home, stopped sending money. So like that would qualify as separation. But she's still, so the difference between, so a couple people are hung up on saying that the separation seems unclear, but she would, during the marriage, before she said the marriage was over, she was sending money home and she would still come home and stay with him. After she made the statement, there's no intent to remain. Whereas previously there is, I'm saying intent to remain, intent to like be married. So it really goes on like the intent. Did you have, separation with intent to permanently move out? So that's what it's based on. So you could definitely make an argument and talk about, well, was it unclear? Was she really separated? I think that she was, but you could make a counter argument there. I totally see that. I think that's valid. Oh, and yeah, so that's H's debts. Could H's debts be paid with the investment income? Yes, H's debts could be paid with investment income. But if it's her separate property, if it's Wendy's separate property, then she is going to be entitled to reimbursement, just like she is for the bank loan, especially because there was a fraud. There was the fraudulent signature there. Okay, now let's talk about essay number 2. So I expected con law, I expected commerce clause. So this was not a surprise to me at all. But it was, it's hefty. It's a hefty essay. So I always start looking at the call to questions. So what claims can Chemco Inc. make under the U.S. Constitution? How should the court rule? Discuss what claims can A&L Berries make under the U.S. Constitution? How should the court rule? And what claims can organic produce make under the U.S. Constitution? And how should the court rule? So con law, right? Con law. And it's interesting to me that there's Chemco Inc., A&L Berries, there's no Inc. there, and Organic Produce Inc. So they very clearly wanted to make a corporate distinction between 1 and 3 as compared to 2. So that makes me think privileges and, privilege and immunity, because you don't have a claim if you're a corporation. You can't claim that. So, but you do if you are not a corporation, if you're a person, or something, maybe another entity type, which we will discuss. So State X has many small farms selling organic produce, which is grown without the use of any chemical fertilizers or pesticides. So you need to know, okay, well, what does this apply to? Instead of using chemical fertilizers or pesticides, these farms organically enrich their soil with animal manure products from State X's large livestock industry. Recently, State X enacted the Organic Farming Act, Organic Act. Section 1 of the Organic Act bans the sale commerce, and use of chemical fertilizers and pesticides in State X, and also bans the sale of any produce grown with or treated by chemical fertilizers and pesticides. So there's section 1. We'll have to look at that. Who does this apply to? We have 3 different defendants, right? Who does this apply to? Also, I noticed that this is not discriminatory on its face, right? It applies to everybody. It applies to everybody. Section 2 of the Organic Act requires that all publicly funded State X institutions only buy organic produce grown in State X. So I'm like, okay, now we have this one, publicly funded State X institutions buy organic produce. So is this like state acting as a market participant? So this is big Commerce Clause essay. In the absence of any federal law, this is telling us that there's no supremacy issue. The state, and one thing I want to mention, whenever there is Commerce Clause, you can usually throw in equal protection and due process. It usually will fail. It's rational basis. That's okay. And also look for privilege and immunity. Privilege and immunity, we'll see, does come up for the second call. 1 in 3, you would raise it and dismiss it because it doesn't apply to corporations. All right, but so the bulk of this so far looks like it's going to center on commerce, and then also throw in a couple of additional arguments. Not a big deal. They're very straightforward and easy, but I would also throw in equal protection, substantive due process, both a rational basis, not going to win, and then also raise privileges and immunities. So in the absence of any federal law, the state X legislature passed the Organic Act after concluding that the use of chemical fertilizers and pesticides contributed to measurable environmental harm. So look, there's some, environmental issue here. It further found an increased threat to the health of farmers using chemical fertilizers and pesticides, as well as to the health of consumers of the farmers' produce. So there's legitimate harm here. But so a couple of things I want to point out. I'm really big on, and this is something I wouldn't expect everybody to get. So if you didn't get this, don't worry about it. Not a big deal. I really like to look at the specific words that they use. Like, why do they say certain ththings? Here in particular, it says that there was an increased threat. So there's a threat, but it's not necessarily going to harm, but there is a threat of harm. So I'm like, well, is that sufficient to meet any standard that we have to apply when it's just a threat? But here we do know that there is measurable environmental harm. So it's definitely causing environmental harm, which does, in turn harm people and, everything. But here I thought the threat of health to farmers and to the consumers. So then also it says the state X legislature also declared that it wanted to preserve the existence of small farms and to protect those farmers' way of life. So there is some economic protectionism happening here, which you can't do. So state X has no significant chemical fertilizer or pesticide industry. So they don't have an industry there. Chemco Inc. in nearby state Y is a chemical fertilizer and pesticide manufacturer that has always had a significant portion of its revenue come from sales in state X. So they're selling directly. So this is going to be section 1. Doesn't mention anything about publicly funded state X institutions. So section 2 does not apply to Chemco. So Chemco is just section 1. It's really commerce. We're going to look at the issues. A&L Berries is a partnership. So this is interesting because privileges and immunities would apply to a partnership, and it could be an issue here, that grows and sells organic strawberries in statewide. But the thing I'll say is it's not a big deal. And I bet a lot of people were like, does it apply to partnerships? This is something I haven't really seen before. I know that we know that P&I doesn't apply to corporations, but even I was like, well, yeah, because I know that it doesn't apply to corporations, it applies to other people. And this is a partnership, which is really just a couple of individuals. So it's like, all right, so it probably does apply to a partnership. But if you were unsure of that, and even if you miss this issue altogether, I think that you could still be okay. But we'll see when the selected answers come out, which won't be till June sometime. A&L Berries is a partnership that grows and sells organic strawberries. So they're organic strawberries. So they're not using pesticides. So section 1 does not apply because it's organic. So they're okay. On section 1, A&L Berries sells some of their strawberries directly to consumers in state X. Good to go. However, most of their sales are to Organic Produce Inc., a statewide wholesaler. Both A&L Berries and Organic Produce Inc., they're another corporation, have publicly funded state X customers who now refuse to do business with them because of the Organic Act. Somebody asked, what do I mean by section 1? There's section 1 of the act. There's 2 sections, 2 components that are different, and then section 2. So let's actually highlight that. That's different from this one. They're totally different laws there. So this is a hefty, there's a lot going on here. There's a lot to sort of keep track of, I think. It's like, okay, well, it says here that A&L sells organic strawberries. So if you didn't pick up in the very beginning, okay, well, what does organic mean? We know what it means colloquially, but it actually does say here, no pesticides. I'm like, okay, so section 1 does not apply to A&L. So, and then Organic Produce Inc. presumably is organic as well. So it's just section 2. So you're saying, okay, well, which law applies to which different individual? Dormant Commerce Clause, section 1, Chemco. This is Chemco's claim. And look, I'm not addressing standing here. I didn't go through all of that here. I do think you should do that, obviously, but I didn't want to put it in here. I don't want to spend a bunch of time because it's very obvious for all of these people that they do have standing. Also, the question here is what claims can Chemco make? So this is what can they positively assert? Obviously, a preliminary issue is standing, but I just didn't include it here just for time. So discrimination against out-of-state commerce. So Dormant Commerce Clause, we always start, is there discrimination? And then is it unduly burdensome, right? So here it's not, there's no discrimination on its face, fine. So we go to, is it unduly burdensome? So it doesn't unduly burden, it burdens interstate commerce because it's limiting what can be produced and sold in state X. There is a legitimate local interest, right? They want to protect health, but they're also protecting the economic interest, which you can't do. So there's environmental protectionism, which you can't do. So this, we concluded that it violates the Dormant Commerce Clause here. And this recording will be posted probably on Monday because tomorrow's Sunday. My team is off on the weekends during the non-crazy bar time. I would also throw in equal protection, due process, and privileges and immunities. Like I said, here there's no protected class for equal protection because it's just like organic farmers, non-organic. Rational basis, this argument would fail. Due process, there's no fundamental right. Again, rational basis, it would fail. And then privileges and immunity doesn't apply because Chemco was a corporation. All right. And I don't know how many points you would lose if you just did Dormant Commerce Clause. I think you could really do okay. But that I won't know until we get the others. Each of these are really small though. These are all really small. I don't, and I think you could. It depends on how you did your organization. So somebody asked if it's okay if you merge the analysis for all parties. I wouldn't have, just because they asked you 1, 2, 3. So I wouldn't have done that because of the way they formatted the questions. But I think it's okay as long as it's clear what you're analyzing. And then A&L berries. So again, they're organic growers. So section 1 does not apply. Discrimination. So you can only buy organic produce grown in state X. So it's discriminatory on its face. But here you have state as a market participant. So state X is the buyer because it's publicly funded state X institutions. So it would not violate the Dormant Commerce Clause here. But, and then equal protection, again, same thing. You would just say, same as, similar to what happened above for equal protection and due process because it's not a protected class. So equal protection and due process are very minimal here. And I don't know that they're totally necessary to pass. Privileges and immunities, I do think is important here because A&L is a partnership. They made that clear. Like that's why every fact in an essay is important. And it's definitely important here because A&L being a partnership means that privileges and immunities does apply, and it violates the right to support oneself because it bars an economic transaction. So that's where privileges and immunity comes in. And if you have a question, instead of raising your hand, if you could type it in the Q&A, please, that way I can get to it timely. And then with respect to organic produce, yeah, Miriam, that's fine, yeah. So with organic produce, again, it's really similar to what we did for A&L berries. And you'll notice too, like if you look at how much discussion there is for each particular defendant, how much they're addressed in the fact pattern, that gives you a hint as to really where the points are. There's more discussion. More of the fact pattern is devoted to 1 and 2. Yeah. So it's really similar for organic produce for the Dormant Commerce Clause analysis, and then also privileges and immunity, OP, organic produce as a corporation. So this one is, you're addressing the same issues, but it's a different outcome. So with the facts are a little bit different. It's a different outcome, specifically with privileges and immunities. All right, yeah, and there was a lot going on in this essay. I definitely think there was a ton here. All right, let's look at question 3. But I find like con law is just generally tough for most people. I thought this PR essay was also a little bit difficult, especially there's 5 different points you had to make. That's Alex, it depends. So you can't, that's true that 1 or 2 missed issues yields a score of 55 or 60, but we don't know. In order to say that, we have to say, okay, well, what did the bar examiners say were the issues that were necessary? So if it was one of the big issues, generally missing a big issue is going to result in a 55 or 60. But if we look and they say that those were the smaller issues, then that can dictate a little bit differently. So that's why I intentionally don't give that here, because we don't know that yet. We don't know that until the selected answers are released. So you can't necessarily say what that is. And, it's like I said in the very beginning, sometimes like you think of stuff during the exam and you write it down and you deal with it quickly. No, it's fine, but like that's the reason why I just like to give that. So, all right, let's talk about essay 3. Let's talk about PR. So what ethical violations, if any, has Allison committed with respect to request free season tickets, payments to Wilfred, payment to Eileen, presentation of Eileen's expert opinion, and Allison's statements in the closing argument discussed. So PR, this is a bit of a racehorse PR. I don't like having 5 different issues, but that's where we're at. So Allison, a criminal defense attorney, represented Davos, a professional athlete, through a valid written retainer agreement. So valid agreement, fine. Davos was charged with assaulting Karen at a restaurant. Allison asked Davos to gift her season tickets to Davos's games if she prevailed in the criminal case. So that's asking for a gift. There's a loyalty issue there and also a financial issue there, especially because it's a criminal case and you can't do contingency in a criminal case. So asking for season tickets, that's a contingency payment. You can't do that. At trial, the prosecution presented the restaurant surveillance videotape as evidence, which showed the assault along with the video surveillance expert who identified Davos in the video. Allison presented the testimony of two witnesses, Wilfred, who was waiting tables at the restaurant and saw an argument between Davos and Karen, but did not see an altercation. So one, can they even actually testify as to, they can set the scene, but they didn't see the altercation, and that's important. And two, Eileen, an experienced video technician who testified that, in her opinion, there was no assault based on the poor quality of the video. When Allison and Eileen had previously watched the video together, they both agreed that the video showed strong evidence of the assault. So we're basically paying to change someone's opinion. Can't do that. Violates duty of fairness, duty of candor, etc. So Allison agreed to pay Wilfred an hourly fee, roughly equal to his hourly wages and tips at the restaurant for his time in testifying. And notice that they put the "and" in italics. They want you to talk about these things. So these are two separate things. One, can you do? One, you can't do. You can't pay like a third-party witness or like an eyewitness, someone that's not an expert. You cannot pay them for prep time. So violates duty of fairness. So, but you can pay them like reasonable. You can basically compensate them for lost wages, essentially, which I think is fairly set. But only if Wilfred refused to meet with the prosecution before trial. So they're only doing that. So they're basically influencing the witness if they refuse to meet with the prosecution before trial. So that's also duty of fairness. It's really duty of fairness, influencing a witness. So once Eileen agreed to change her opinion and testify that there was no assault based on the quality of the video, Allison agreed to pay Eileen $500 per hour for testifying at the trial. Tiny little side note for all y'all later on in your career, become an expert witness because you get like $500 an hour and it's so easy. Anyways, Allison agreed to pay Eileen $500 per hour for testifying at the trial. I tell all my friends to become expert witnesses if they can. In her closing argument, Allison argued that the video showed that there was no assault and that, in her own opinion, after considering the evidence, Davos was not guilty. So what ethical violations are there? Request for season tickets to Davos's games. So one thing I want to point out, there's 5 particular calls, and there are fewer issues I included per call because there's so many calls, and that's really common. If you have a lot of calls, it's going to be a little less in depth for each call. Same, we see this in evidence as well. When you have, 6 calls, 8 calls, it's just a little bit in each, or, maybe some are longer, some are shorter, but, all of it's designed to be completed in an hour. So loyalty, you can't solicit substantial gifts from clients. Season tickets would be considered substantial. There's a little bit, to discuss there. Why is that? Season tickets are expensive. Pretty straightforward, but still. And then duty of financial responsibility. It's a criminal case. No contingency fees are allowed in a criminal case. This is a contingency because he said, if I win. Right, so that's contingency. Payments to Wilfred, duty of fairness. They're paying more than the reasonable rate. I actually want to edit this a tiny bit. Duty of fairness, and also for the refusing to meet with the prosecution before trial. Yeah, the refusal to meet the prosecution before trial is also a fairness issue. Maybe it's also candor because it's to the court, but paying more than a reasonable rate. They can pay for I didn't put all the facts in here. But you'd want to definitely talk both about the, compensating for wages lost and the entire day of preparation. So they're overpaying. The payment to Eileen, duty of fairness, agreed to pay only upon changing her testimony. Duty of candor, allowing somebody to perjure themselves, basically. Duty of candor to the court. We know that Eileen is basically presenting false testimony. It's not actually her opinion. And yeah, you could also talk about the $500 an hour being an unreasonable fee. It actually is a reasonable fee. Like, I had experts all the time that were like $900 an hour. It's really, and that was, God, almost 10 years ago. And it is okay to say something else. You don't have to follow, like I say, duty of fairness, duty of financial responsibility. You can call it something else. You could say duty to not influence witnesses. Like, it doesn't really matter. You can use all sorts of different terms. It's really about getting to the legal issue, the ethical issue. It's not necessarily about calling it the exact right thing. So that's something that is totally okay. So payment to Eileen, payments to Wilfred, that's problematic. I actually probably would have broken up. One thing I want to point out that I just noticed, even though I typed it, is payments to Wilfred, and here it's payment to Eileen. So they really do want you to see, plus they italicized the "and." So they're really pointing that out, that there's 2 issues here. One, reasonable lost wages. The other is not meeting with the prosecution. There's California distinctions in some of these. I don't get into them here. There's nothing that's really big. There are differences with duty of loyalty. I talk about that. I have a free PR workshop on YouTube, and it's in my strategy score. It's It's somewhere in my free courses. So business transaction with client and issue. So for I think for duty of loyalty in the first one, you could call it like a business transaction with a client, maybe. But it's really just like, if I win, you give me something. So it's really just payment and it's a substantial gift. So I thought about that too. So I don't think you're wrong for calling it a business transaction, but you should talk about it as a gift also. All right, presentation of Eileen's expert opinion, duty of candor and fairness. This is really for allowing the false testimony for both of those. It's really the same thing. So here it's really the same analysis. So do you need to break it up? I don't know. I don't think it's totally necessary. And then let's look at, I know I'm getting a bunch of questions and I will get to them in a minute. And then Allison's statements and closing argument, again, duty of candor and duty of fairness, because she's making false statements of fact and law. Well, yeah, making false statements and also giving her own opinion. Like, you're not really supposed to do that. You're not supposed to, the attorney's not supposed to testify. This is like one thing where a suits gets like actually gets legal stuff right. I've been like in a suits just binge lately. Somebody asked, would I discuss requirements for making a contingency fee agreement at all? I would at the very beginning talk about is a valid written retainer agreement. I wouldn't go deep into the contingency thing. I would just address it in the first part. That's it. If the contingency is with a client. All of these are witnesses, so that doesn't apply to witnesses. Duty to communicate because the payments to Eileen and Wilfred were not discussed in the retainer. That's part of the fee, like part of the retainer, it covers all of that type of stuff. So you didn't need to talk about duty to communicate now. The way they generally test duty to communicate is with either a significant event or a settlement offer. And if you don't communicate that, that's the problem. And for the first one, for the request for a season ticket, the conflict of interest, yeah, it's really the attorney's own. You just can't solicit substantial gifts from a client. So client self-interest. Yeah. And could you talk about withdrawal? Yeah. I mean, withdrawal is something, it's not totally at issue here. There are definitely violations. So at the very end, you could also say there is probably a duty to withdraw here, given all of the ethical violations. But like the trial, this is basically done. So she should have withdrawn earlier, but they didn't. And then also the other thing you could talk about, which I just remembered now too, is the self-reporting requirement now because of that change. And like competence, this is something I see. So people always like to throw in competence and withdrawal, but it's just not really at issue here. Like competence, they test by you not knowing the area of law is generally what they're like. That's when they want you to talk about competence. Sure, you can throw it in, but it is not something that I would spend a lot of time on because it's not really what they're going after here. But yeah, I do understand how, people throw it in. Just keep it really brief. Just keep it like that's a bit throwing in competence and withdrawal. That's a bit of what I call spaghetti walling, just like throwing a ton of stuff at it. And also like taking the request for the season tickets and doing like 30 violations there and then not finishing the rest of it. You have to manage your time, know what are the bar examiners looking for on this issue. So, and yes, for issue A, yeah, loyalty and conflict of interest. Well, loyalty is a conflict. That's the same one and the same. All right, let's look at essay 4. This one, not so bad, I thought. Not so bad. All right, so this was Crim Pro, an expected issue. Duty of, or I'm thinking PR now, right to counsel. So Sixth Amendment right to counsel post-charging. All right. And then also Cal evidence. So not such a crazy evidence issue, but there's some kind of interesting stuff in here, I thought. So Acme Bank was robbed in December 2022. On January 15th, 2023, Dan was charged with robbing bank. So as soon as I see charge, I think, all right to counsel is attached. In April 23, Officer Pat showed Tessa, the teller who was robbed, photographs of 6 men, each of whom were the same race, approximate age, and had blonde hair and a mustache like Dan. So I see, I'm like, oh, it's a photo lineup. Often when they do that, or it's just like a photo ID. When they do that, there's often a due process issue if it's really obvious. Like if we knew that the robber had dark hair and it's 5 pictures of blondes and 1 person with dark hair, then it's unfair. But we don't have that here. So here it meets due process. Also later on, they tell us specifically that it's just right to counsel. But something else to look for, they did test that in a big essay in like 2019 or 2020, within the last few years. They did a big due process essay. All right, so Tessa immediately selected the photograph of Dan, saying he was the robber and signed her name on it. So she's ID'd him. Before trial in the Superior Court, Dan moved to suppress the photograph under the 6th Amendment to the U.S. Constitution, claiming that it should be suppressed because his attorney was not present when Tessa was shown the photographs. The motion was denied. So Sixth Amendment right to counsel, it attaches, and you have a right to counsel at all critical stages, including lineups and show-ups, but it doesn't apply at photo identifications. We double checked on this because I wanted to be doubly sure, because I haven't seen this particular issue come up in a while, but it doesn't apply at showing a photo. But the thing that you can object to, like I said, is due process, but we don't have that here. And I wouldn't have raised that because they only objected, they only moved to suppress on the grounds of lack of counsel. At trial, the party stipulated that the photograph Tessa had selected was neither a business record nor an official record. So I'm getting now at hearsay, that it's not either of those. The prosecutor called Tessa, who in court identified Dan as the robber. On cross, defense counsel asked Tessa whether she had made a statement to the defense investigator in February 2023. So we're getting at a prior inconsistent statement that Tessa admitted to that the robber had black hair and no mustache. So before, it's blonde hair and a mustache. Now, black hair, no mustache. On redirect, Tessa again identified the photograph of Dan as the robber. This was the same photograph Tessa had signed previously. The photograph was admitted into evidence. So prior inconsistent statement, but the first statement to the investigator was not made under oath, so it wouldn't come in as hearsay. There's a question: are you offering it for the truth or not? And the prosecution is offering the photo for the proof, and then the question, the prior inconsistent statement, the question about what the robber looked like, or about her saying that the robber had black hair, no mustache, we are offering that for the truth, ideally, but it doesn't look like we have a hearsay exception. Definitely not prior consistent statement. They said it's not a business record or an official record. There's no other exception that I can think of, but you can get it in for another purpose here. Oh, and then does not have to be an under oath to be submitted substantively. Okay, I was thinking, I'd have to double check, Christina. So, but here we could use it for impeachment, and the photograph is admitted into evidence. In the defense case, Dan testified that he was not the robber and that he had been visiting his mother in Alaska for 3 weeks, including 1 week before and 2 weeks after the robbery. So trying to have an alibi. So we want to think relevance, obviously, and all of these. So relevance for the photograph is to ID the robber. And then Dan testifying that he's not the robber, that he had been visiting his mother in Alaska for 3 weeks, including 1 week before and 2 weeks after. That is also an alibi. That's an alibi. And then in rebuttal, the prosecutor called Chet, the custodian of records from Credco, a credit union. Chet identified records from a Credco automated teller machine, ATM, located down the street from bank. Chet testified that the ATM records were created as part of Credco's regular course of business, so we're looking at business record. Chet further testified that the records reflect a withdrawal was made from Dan's account the day before the robbery using a PIN assigned to Dan's account. So they're trying to dispute his alibi, so it's definitely relevant. Hearsay, I think it's a machine-made record, so I don't think it's hearsay. But even if it was, you could probably admit it as a business record, So did the court properly deny Dan's motion to suppress? Post-charge right to counsel has attached, but there's no right to counsel at a photo ID. And Smeeta, I'll double check that, but I actually don't think so. We double checked this the other day. Assuming all reasonable objections were timely made, did the court properly admit under the CEC? T's testimony about her statement to the defense investigator, bring up relevance. Again, it was relevant to ID him. Can somebody just double check in California? Does it not have to be made under oath? That I actually don't remember. I want to double check that. Oh yeah, even if they're not made under oath, as long as the witness was so examined while testifying. Yeah, so it doesn't actually have to be under oath. So that made a little bit, that should be allowed. Yeah, you have to be given the opportunity to explain or deny. So it actually could work here, prior and consistent statement. Yeah, thank you. A's testimony about her statement to the defense investigator. So relevance, hearsay. Let me just change that right now. Sorry, everybody, give me 1 second. Thanks for that. And then the photograph with T signature, relevance, it's really just relevance authentication secondary evidence rule, or best evidence rule, but in California we call it the secondary evidence rule. And that would be okay. Yeah, that would be okay. I also thought here there's a signature, and I'm thinking, okay, well, signature, authentication, all of that, but I wouldn't even really get into the weeds on that. It doesn't look necessary here. And if you said the rule, if you got it mostly correct, said right of counsel attached at the photo ID, I think you're fine. And we had a whole debate about this the other day, about the photo ID right to counsel. So generally speaking, if you get a rule, like if you do it a little bit wrong, you're mostly okay. People make mistakes all the time. It's okay. And then ATM records, relevance, hearsay, business record, it would be a business record. I would talk about it maybe not even being hearsay because it's mechanically produced, but you know, even if you said that it was hearsay, then it would come in as a business record. And also because it's the records themselves, authentication, I should say secondary evidence rule, not BER. Oh, and impeachment should be on the next line. Sorry, y'all. So relevance, hearsay, prior consistent statement. Oh, and then Prop 8. Yes, got it. Didn't put Prop 8 on here. Yes, obviously Prop 8. Prop 8 wouldn't make a difference, but you would always start by addressing Prop 8. So talk about Prop 8 at the beginning of the essay, and then for each piece of evidence, does Prop 8 does it change the outcome? And it doesn't, and it wouldn't change the outcome here. But yes, obviously Prop 8. Let's look at essay 5. This is a brutal contracts remedies essay, I think. Did you guys feel that way? Did this essay feel tough? I thought it was really difficult. And we went back and forth on it quite a bit because I go through the essays and one of my colleagues goes through it, and then we get together and compare notes. And I thought this was just absolutely brutal and confusing. I was just like, oh, this is I thought. And a lot of people, how many of you guys were not expecting contracts remedies at all? Like, that's just why I say anybody that was in my class, you all know that I say always expect remedies, and usually expect remedies and contracts. Yeah, I always say it. They love remedies is the second most frequently tested subject behind PR. There's so many remedies essays. So let's talk about this one. So is there an enforceable contract between Brian and Sam? If so, what are the terms? Super fun. And it was confusing. It's so confusing because there's so many ambiguities. I was like, well, I'll talk about that in a minute. I thought this was just a beast. And then is Brian likely to prevail on his claims against Sam? If so, what damages is he likely to recover? On this essay, if you came to different conclusions from me, I think it's totally okay. I think it is. I really do think reasonable minds can differ. There is so much, I think, ambiguity here. And I'll tell you about the issues that we were like, well, could you do this? Was this a mistake? Was that like, I think there were so many things that were kind of confusing here. So if you felt thrown off by this, totally get it, totally valid. And I think that the scores on this are going to be kind of wild. All right. Brian, owner of a commercial bakery, and Sam, owner of a bakery supply business, B&S, buyer, seller. It's always nice to just like distill it down to that. To keep parties straight, because it's with its names, it's so much harder. So met for the first time and discussed Brian's inability to find a reliable source of maple topping. When Sam told Brian he could supply the maple topping, they orally agreed, statute of frauds, that Sam would immediately ship 500 gallons of topping at $20 per gallon. Sam then added that he did not want to ship without something in writing, and Brian replied, I will send written confirmation tomorrow. So he says he's going to send written confirmation tomorrow, doesn't, obviously. For the next 3 weeks, Brian was busy negotiating a conference center catering contract and forgot to send Sam the confirmation. So he forgets to send it, right? So then it's like, well, how formal are these people in dealing with each other? And I just thought so much of the language here was confusing. But it's supposed to be 500 gallons of topping, $20 per gallon. So Brian's busy negotiating a conference center catering contract, forgot to send Sam the confirmation. The catering contract obligated Brian to provide large quantities of pastries with maple topping, obviously. Brian then recalled his promise to Sam and sent him a purchase order on his standard form for 5,000 gallons of maple topping at $20 per gallon to be delivered to Brian's place of business in 2 weeks. So change from 500 to 5,000, which is a big change. And I was like, well, given that it's 500 to 5,000, was that a mistake? It probably is intentional because Brian has now gotten this big contract. So it probably was intentional, but like this single digit off often is a mistake, and it's usually a Scrivener's error, which changes the analysis. So if you thought that, I understand that, but it looks more intentional. And then was it like intentionally changing the terms, like hoping they wouldn't see it, which is like a little shady. So there could be that. Maybe I'm thinking too deeply into this. And I always say, if you get like on that track where you're thinking very deeply into something, often it's better to take the simple analysis, but we'll see. So send him a purchase order in standard form for 5,000 gallons of maple topping at $20 per gallon to be delivered to Brian's place of business in 2 weeks. So it's supposed to be delivered in 2 weeks. But initially, there was supposed to be an immediate shipment of the 500 gallons. So it's supposed to be immediate. Sam received Brian's purchase order, but did not notice the change in gallonage. So he doesn't notice it. So he makes a mistake. So he doesn't notice it, which also means so now there is this writing, right? There is a writing. Now there's a merchant's confirmatory memo. And if there's a change to it, so we're under the UCC, if there is a change to the original agreement, then we have to say, okay, well, is it, if there is a change, is it a material change? And it would be, right? So it is a material change, but there's no objection to it. There's no objection. So So failed to object, which poses a problem, and there probably is an enforceable contract here for what was written, the 5,000 for $20 per gallon. So, but you might have said, like, I think that somebody, you could reasonably argue that because they ask you what are other terms. So you could say, well, for a variety of reasons, it should have been 500, but he saw the delivery date, but in light of Brian's delay in sending the confirmation, he did not believe it was firm. So he thinks it's a flexible delivery date. So he doesn't think that it's firm. The same day, Sam sent a signed acknowledgement restating Brian's purchase order items and then left on a 4-week vacation to a remote locale. So he's going to breach, right? So the terms were supposed to be based on this 5,000 gallons, $20 per gallon to be delivered in 2 weeks, right? So it's to be delivered in 2 weeks. So if you have to have perfect tender under the UCC. So not delivering within 2 weeks, that's a breach. So it would be breach no matter what. I think you could differ on what I'm saying, what the terms are. And yeah, Gina, I think you're right. So upon his return, Sam shipped 500 gallons of maple topping to Brian. By that time, Brian was in default of the catering contract due to lack of maple topping. Brian had tried, but had been unable to reach Sam while he was on vacation because Brian had been unsuccessful in obtaining an alternate source of maple topping. So he did try. The conference center canceled its contract, resulting in $100,000 in lost profits. Okay, so lost profits, you're not gonna be able to get here, not foreseeable. So is there an enforceable contract? So UCC plus the merchants here, merchants confirmatory memo. So here, time of formation is unclear, but there is an agreement and the essential terms have been agreed upon, the price and quantity. Defense of formation, statute of frauds, but there was a merchant's confirmatory memo valid up to the amount stated. Unilateral mistake, 5,000 versus 500. I don't think that there was a mistake. We don't think it was Scribner's error because it's what he's suing for and because he'd been negotiating this catering center contract. So there is a valid contract that it has been formed, merchant's confirmatory memo plus no objection by Sam. So I do think that there was a valid contract formed. And I think that the terms were the 5,000 gallons. That's what's written. There was no objection. $20 per gallon, deliver in 2 weeks at Brian's place of business. These would be the terms. But I do think that there is an argument that it should have been 500 gallons. So I would definitely talk about that. And I think you can definitely, Is B likely to prevail on his claim against S? If so, what damages? So terms were 2 weeks, 5,000 gallons. He sent them 4 weeks later, 500 gallons. So it's not perfect tender. S might argue, so this is something that I think is like kind of funny. But S might argue course of performance regarding the deadline so you might say, well, it wasn't a firm deadline. He says he didn't think that it was firm because it took him 3 weeks to send the thing he was supposed to send immediately. He was supposed to immediately send the writing and he didn't. So maybe Sam thinks, well, these terms are a bit loose. There's no time is of the essence. There is no time. I'll go back in a minute. There's no time is of the essence written here. I think that it's a loose date. And because it seems loose, given that the delay, I think that it is a little bit loose given the delay in sending the initial agreement, the written agreement. So he can prevail, but he cannot recover lost profits because lost profits were not foreseeable at the time of the contract because the time that they actually came to the agreement was prior to the negotiation for the conference center contract. So he's not going to get those lost profits. And it really looks like all he's seeking is the $100,000 in lost profits. So he won't get that. I don't think that the offer expired just because of the delay though. And somebody had asked for this. So brutal essay, right? I don't think the course of performance is a big deal. And if you miss they're only asking the lost profits. You could talk about what other damages. The question said what damages, but he's only suing for lost profits. So that was my focus. You could argue, somebody asked, could you argue that the merchant's confirmatory memo didn't meet the statute of frauds because it took 3 weeks? I think you can argue that that's unreasonable. I don't think that argument would win. And the thing is to say, okay, you can argue that, and even if you conclude that, argue the opposite and proceed as if it does work. Yeah, somebody said they argue the lapse of time and the difference in terms would cause a second contract to be enforceable. Yeah. And I do think you could talk about 2207, like knockout. You could talk about that here, but that's usually when like two parties have different terms. That's usually what it is. So where it's not. Yeah. So this is, brutal. But I think SA4 wasn't so bad. So then they have this. I don't think February exams are harder than July. The evidence does not bear that out. Just FYI, like it doesn't bear that out. I know a lot of people think that, but yeah, it doesn't actually bear it out. All right, you guys ready to talk about the PT? And like I said, this is kind of like big picture overview of the PT. I will do a workshop later where I go a bit more in depth into the PT in particular. All right, so this was persuasive, classic persuasive, memorandum of points and authorities, which is persuasive. I did discuss damages. Yeah, it was just the lost profits and you wouldn't get them. All right, so memorandum of points and authorities. So special formatting instructions, no intro, no conclusion. So just an argument section. Fine, easy. I think people were thrown off by that from what I heard. But fine, that just means that it's going to go a little bit deeper in the argument. So you get those extra few minutes in the argument. And intro and a conclusion, I do always like to include them. Otherwise, I haven't seen them state this before that I can recall, but it's just a couple of minutes. So organization's not given in the task memo, which I think makes a PT a little bit tougher if they don't say these are the issues, because then the setup you have to figure out on your own, which makes it a tough issues. But you usually organize by law in these instances. And here you're going to organize by the statute that they give you, which is the Good Samaritan Act. So these are the issues that I saw. This is what I would have done. So argument. So defendant John DeHere is entitled to summary judgment because there's no genuine issue of material fact. So major rule that goes first is the standard for the MSJ. And whenever you're talking about an MSJ, when you have a standard like this, you weave that in throughout the entire argument. So you always weave that in. So genuine issue of material fact. So first issue, and I love it when it's persuasive because I know what my conclusion is going to be because I know what I need to argue. So we were asking for an MSJ, right? So let me actually go to the task memo. Yeah, so Anton Panko is the plaintiff, brought a negligence action against our client, John DeHere. Mr. DeHere and Mr. Panko were injured in a vehicle accident after DeHere stopped at the scene of a prior vehicle accident and Panko collided with his vehicle. Discovery has been completed. We will now file an MSJ on defendant's behalf, supported by a persuasive brief, arguing that there was no triable issue of material fact that Panko's action is barred by Columbia's Good Samaritan Act, and defendant is entitled to judgment as a matter of law on that basis. I've attached relevant portions of the previous discovery. Please draft a memorandum of P's and A's to support the motion. Do not include an introduction, a section of the factual background and procedural history, or a conclusion. Oh, I should have said no statement of facts. Though obviously you should incorporate the facts into your argument. I will draft them after I edit your memo. They're already telling you they're going to edit it. Just fun. Okay, so this is how I wrote it. So I just said there's no genuine issue of material fact. So the way that, I'm going to take a step back. The way that the rule is there was two components for the Good Samaritan Act. Let me go to it. It just says it doesn't apply to services rendered by a healthcare provider to a patient in a healthcare facility. We're really focused on section B. So a person who comes upon the scene of an emergency or accident or is summoned to the scene of an emergency or accident and in good faith gratuitously renders emergency care at the scene of the emergency or accident is immune from civil liability for any personal injury that results from any act or omission by the person in rendering the emergency care or any act or failure to act to provide or arrange for further medical treatment or care for the injured person, except for acts or omissions amounting to gross negligence. So we have, section B1 and section B2. So I'm automatically going to have two major sections. The first one is focused on B1. So he's immune from civil liability for personal injury for rendering emergency care. And I want to know, well, what does that mean? So the case law further explains what that means. And then when I go to the cases, they explain, one case explains section 1, one case explains section 2. So if you go to the cases, there's Chung. There's a lot of rules. I thought this PT was fairly rule heavy, and I will send out my answer to this too. So if you want to see my written out answer, we will send that. So, but in this PT, in Chung, they talk about issue B1. So this, under the Good Samaritan Act, the first, sub issue here, it talks about whether if you want to prove liability or if you want immunity from liability under the Good Samaritan Act, you have to show that both of these things, essentially that your actions that you rendered actions which you reasonably believed were required to prevent death or serious injury, and you reasonably believed you could successfully undertake them, or that you rendered actions that you reasonably believed would benefit an injured or ill person and reasonably believed you could undertake them. So I just have a section on each. There's no genuine issue of material fact regarding whether Mr. DeHere's actions were in conformity with a reasonable belief that such actions were required. I just took each of those alternatives and had a little section on each. Here, 1 and 2, go to issue. This is issue A and issue B. Does that make sense to everybody? And I pulled everything from, I would get the rule from GSA and from Chung. And importantly, on the Cal Bar, ever since they changed to one 90-minute performance test, ever since they made that change, you've had to distinguish and analogize too. So you're going to have one case in your library where we come to the opposite conclusion. So I'm going to argue I have to distinguish the facts of my case from the facts in Chung, which is a little bit tougher to do. That's definitely a little bit harder to do. Does that make sense what you had to do here? Okay, cool. Just want to make sure. I don't send out my essays, but I will send out for those of you, for certain people, or I will send it out to everybody that was registered for this, my PT. Send it out later this week. Okay. Then second issue is just this, just the second issue under the Good Samaritan Act, which is basically, he didn't act with gross negligence. So Mr. DeHere is immune from liability because there is no genuine issue of material fact regarding whether Mr. DeHere acted with gross negligence when assisting Mr. Pankow, or it should say Mr. Tran, rather. And then you get your rules from Miller. It's in the second case, and then analogize to Miller. Oh, I don't think that was. I think they were responding to my question. So I will send out my answer to this question. So D, you're arguing that D is not negligent, exactly, because you want the court to grant a motion for summary judgment in your favor that he's not negligent. And you could absolutely do this here. There is some ambiguity, but I'll go through that in my answer. So that's it. Oh, I did do 90 minutes, which is good. Yeah, and it would be okay to put conclusion at the end of the rule of analysis. Yeah, just looking at the questions left in the chat. Generally speaking, you're going to have to do some distinguishing on the bar in the PT. So in this instance, oh, yeah, it says no overall conclusion. So you would still conclude on an issue, but you don't do an overall conclusion section, is all. But you do have conclusions actually in your motion. You would always have that. But yes, on a PT since July 2017, in every single performance test, I have seen analogizing to one case. So our facts match theirs and we come to the same conclusions. And also that one case, they come to an opposite conclusion of what we want. So we have to distinguish from that case. Yeah, James, yeah, exactly. You would be penalized for an overall conclusion. Yeah. Do I recommend doing an outline on paper, just starting? I think that varies person to person. Somebody asked if I recommend doing an outline or just starting typing and organizing. I just go straight and do it. I think but sometimes it does help people to like sketch a little bit of an outline on paper too. I think that's fine. And then somebody asked my early intervention course. It's not exactly the same. No, there is a lot of similarities, but it's not exactly the same. I have no idea how many points would be lost. All right, everybody. Thank you so much for joining me. Also, we do have our class that starts tomorrow, early intervention. I hope to see you all there. And yeah, if you guys have any other questions, please feel free to reach out. You can schedule a consult for July bar prep. You can schedule a consult if you want to have a chat. And if you guys need anything else, you have any other questions about the books or just anything else. Oh, Madeline, I didn't see. Oh, thank you. What are they doing in February 25 that's different? We don't know yet is the answer, but they're not using NCBE, MBE questions. So they will be doing multiple choice, but they're not going to use the NCBE ones. We don't know what that will look like yet. So it's TBD, basically. Thanks so much, everybody. Thank you so much. Look forward to chatting with some of you or a lot of you or all of you, and hopefully see you in class. Thanks, everybody. Bye.